Types of tenancy. 1. Tenancy for a fixed term. Simply put, a tenancy for a fixed term is one that is set for a predetermined amount of time. When a tenant breaks a condition of the tenancy, whether explicit or implicit, the tenancy either ends when the specified time runs out or is terminated by the landlord through the forfeiture procedure. In addition, the landlord must notify the tenant of their plan to file a court application to regain ownership of the property when the allotted period has passed, as according to Section 13 of the Lagos State Tenancy Law 2011. 2. Periodic tenancy. As the name implies, periodic tenancy simply refers to a tenancy that lasts for a set period of time. Either the number of occupational units of time or the frequency of rent payments are used to quantify this tenancy. Tenancies lasting 1 month, 3 months, 6 months, or a year are the most common types. Recall that the conclusion of the term, a periodic tenancy, is often renewed by paying rent for a new one. It usually lasts for a long time until it is appropriately resolved by the issuing of a legitimate notice to quit. The difference between a tenancy for a fixed term and periodic tenancy is that periodic tenancy is renewable after expiration of the tenancy period, while tenancy for a fixed period of time is not renewable. This kind of tenancy is typically terminated by giving notice to vacate. An annual tenant is entitled to 6 months' notice. A half-yearly renter is entitled to 3 months' notice. A quarterly tenant is entitled to 3 months' notice, and a monthly tenant is entitled to 1 month's notice per Section 13 of the Lagos State 2011 Tenancy Law. This provision is also applicable in Delta State, Cross River State, and Abuja. Statutory tenancy. Number 3. A statutory tenant is an occupier who, despite other landlords' insistence on having him evicted from the premises, continues to possess the latter's property after the terms of his contractual tenancy has expired. Now, this implies that the landlord is not permitted by law to evict the individual even after the agreed upon tenancy has ended. Number 4 is tenancy by estoppel. A tenancy by estoppel arises when an individual rents out a property in which he has neither title nor interest. Now, the landlord-tenant relationship cannot be denied by either the landlord or the tenant. This type of tenancy is also governed by terms of an expressly entered into tenancy. Tenancy at will. A tenant at will, to put it simply, is one whom the landlord grants permission to occupy a property for an unspecified period of time. Now, this kind of tenancy typically lacks a formal tenancy agreement that would outline the terms of the lease and how long the tenancy would last. Normally, the tenancy has to have a specific length of time. However, a tenancy at will just has a tenure and no specified time limit, since any party can choose to stop the agreement at any time. Although not exclusive, the following are some instances of tenancy at will. When a person is granted rent-free occupancy of a space for an unspecified amount of time. When a tenant whose tenancy has expired continues to occupy the space without paying rent to establish a new term, or when a tenant continues to occupy the space after a notice to vacate or the end of a predetermined term, but his landlord does not take proactive measures to reclaim possession. Now, when a buyer has been granted possession of property while the deal is still pending. Legal implication of tenancy. The legal implication of a tenancy is that both parties to the agreement, that is, the landlord and the tenant, having signed the tenancy agreement, are now bound by the terms in that agreement. Any deviation from the terms of the agreement by either party can lead to the other party seeking redress in the court and, in some instances, treating the agreement as void. One of the instances in which the landlord is entitled to treat the agreement as void and proceed to evict the tenant is violation of fundamental term of the tenancy agreement. For example, using the premises for illegal purposes. Rights and obligations of landlord and tenant. The purpose of landlord-tenant legislation is to serve as a framework for rights, obligations, and interactions between landlords and tenants. State legislation may vary slightly, but there are some common requirements, rights, and obligations owed by the landlord to the tenant. Rights of the landlord are as follows. 1. The right to payment of rent due. 2. The right to repossession of the property on the expiration of the rent. 3. The right to inspection of the property at agreed time with the tenant. 4. The right to sell the property as he has ownership right even during the pendency of the tenancy or lease. 5. The right to sue for damages done to the property not for reasonable wear and tear. The obligation of the landlord to the tenant are as follows. 1. The responsibility of providing the tenant with payment receipts. 2. The responsibility of making sure the property is free of occupants on the day of the tenant's move-in, clean and safe. 3. The responsibility of issuing the property. 4. The duty to maintain the security of the property. 5. The obligation to adhere to the conditions specified in the tenancy agreement. 6. The responsibility to allow the tenant enough room to enjoy the rented property, for example, by minimizing needless frequent visits. 7. The duty to pay taxes and all outgoings under the tenancy agreement.